right, let's talk about gratitude. You've probably heard the word thrown around, but do you really know what it means for your wallet? Because let me tell you, it's not just some nice farewell bonus from your boss. It's a serious financial right, and understanding how it works is absolutely key to getting the money you have rightfully earned.
So, here's how we're going to break it all down. First, we'll get into what gratuity actually is and what it isn't. Then, we'll tackle the big one. Are you even eligible to get it? After that, we'll get into the fun part, the numbers, and figure out how to calculate exactly what you're owed. And finally, we'll take a look at what's coming next, because this whole system is changing.
Okay, first things first. Let's just shatter the biggest myth about gratuity right off the bat. So many people think of it as a gift, a generous thank you from a company for your years of service. But that could not be further from the truth.
And look, this isn't just my opinion. This comes from the highest court in the land. The Supreme Court of India has made it crystal clear. Gratuity is not a gift. It's an earned, deferred wage. In other words, it's your money. It's a piece of your salary that you earned all along, which was just held back to be paid to you when you leave. Think of it like a mandatory savings account your employer has to keep for you.
So what this means for you is that this payment is a legal obligation. It's not optional. It's a lump sum amount, totally protected by law, and it's designed to give you a bit of financial security after you've put in the years. It's your loyalty, rewarded and written into law.
Before 1972, it was kind of a mess. It was a total free-for-all with different rules in different states and different companies. It was completely unfair. So, this act came in and brought order to all that chaos. It created one single, uniform standard for everyone, making sure your rights are protected no matter where in India you happen to work.
Okay, so let's get to the question I know is on your mind. Do you actually qualify for this? The rules are pretty specific, but they're not nearly as complicated as you might think once you know them.
This is the one everyone knows, right? The big 5-year rule. You have to work for 5 continuous years with the same employer. Seems pretty straightforward, but wait, there's a crucial little detail here that can make all the difference. And here it is, 4 years and 240 days. Seriously, remember this number. The courts have clarified that 5 years of service doesn't necessarily mean 5 full trips around the sun. If you work for 4 years and then at least 240 days into your 5th year, legally, that counts. You're eligible. That little detail could literally be worth thousands or even lakhs of rupees.
Now, the law also has a heart. It includes this really important humanitarian clause. In the tragic event of an employee's death, or if they suffer a disability that makes it impossible to continue working, that 5-year rule is completely waived. The gratuity gets paid out no matter how long they've worked. It's a critical financial safety net for families when they need it most.
All right, this is the moment you've been waiting for. We know what gratuity is, we know who gets it, but how much money are we really talking about? Let's get down to the nitty-gritty and break down the calculation.
Okay, before we even touch the formula, we have to get this one thing straight, because it trips so many people up. The term wages for gratuity is very specific. It is not your total salary. It is not your CTC. It is only your basic salary plus your dearness allowance, or DA. That's it. Everything else, bonuses, HRA, overtime, it's all out.
So here it is, the magic formula that turns your years of hard work into a final number. You take your last wages, again that's just your basic plus DA, you multiply that by 15, divided by 26, and then multiply that result by your total number of years of service. So why 15 divided by 26? Well, the logic is to pay you for 15 days of work for every year you've served, and it assumes a working month has 26 days.
Let's just run through an example to see how this works. Imagine an employee whose last drawn basic plus DA was 2,50,000 rupees a month, and they've been with the company for 25 years. You plug those numbers into the formula, and you get a whopping 36 lakh rupees. But, and this is a big but, the law has a ceiling. Right now, the maximum gratuity you can be paid is capped at 20 lakhs. So this person would get the full 20 lakh limit.
Now, getting your money isn't some vague, informal process. The law is super strict about it. There's a 3-step timeline. Step 1, you have to apply for it within 30 days of leaving. Step 2, your employer then has 15 days to calculate the amount and tell you what it is. And step 3, the most important part, they must pay you within 30 days.
And make no mistake about it, this law has teeth.
If your employer misses that 30-day payment deadline, they don't just owe you the gratuity. They also have to start paying simple interest on that amount for every single day they are late. It's a powerful incentive to make sure companies pay what they owe and pay it on time.
Okay, so for our final section, let's look to the future. Because the Gratuity Act isn't some dusty old document that never changes. It's a living law, and it's constantly evolving to keep up with the times. And believe me, there are some really big changes on the horizon.
If you just look at the history of that payment ceiling, you see a really clear pattern. It gets raised every few years to keep up with inflation and rising salaries. Just this year, the limit for central government employees went up to 25 lakhs. And historically, wherever the government leads, the private sector tends to follow. So it's a pretty safe bet that an increase for everyone else is just around the corner.
Now, this is probably the biggest change of all. The new Social Security Code, which is expected to replace the old act, is going to completely redefine wages. Instead of just being your basic and DA, it's going to be based on a much bigger chunk of your total salary. The new rule is a bit complex, but the bottom line for you is simple. This change could lead to a significantly higher gratuity payout for millions of employees.
And all of this brings us to one final big question. The Gratuity Act was born in an era of lifetime employment. It was designed to reward loyalty, but we don't really live in that world anymore, do we? In today's gig economy, with people hopping jobs every few years, how does a benefit like this survive? How do we adapt a system built for loyalty to an economy that's built on flexibility? That's the challenge and the conversation that lies ahead. Thanks for joining us.
Welcome to the Deep Dive. We're your shortcut to getting a handle on the legal stuff that shapes, well, the modern workplace. Today, we're taking a closer look, a really deep dive, into a piece of law that often just sits there quietly on the books for, almost every decent-sized company in India. That's the Payment of Gratuity Act, 1972.
Yeah, and it's funny. People often just wave it away thinking, oh, it's just a retirement bonus. But honestly, that thinking is, well, it's pretty dangerous if you're running a business or you're in HR. So our mission today, it's really to smash that assumption. We need to dig into the actual legal terms, the mandatory money side of things, the funding, and the compliance headaches that can turn this simple-sounding gratuity into this permanent, growing, and frankly, often under-budgeted risk.
Okay, let's unpack that. The whole reason this act exists, our sources show it came from a pretty big shift in how people thought about this stuff. Before 72, right, paying gratuity was often just, well, boss being nice. A voluntary gift, maybe when someone retired.
Exactly. That whole view got completely flipped on its head by the act. It basically wrote social justice into law. Gratuity stopped being this optional nice thing and became a statutory right. It's an earned deferred wage, something you actually earn year by year by sticking with the company. It's a vested right. When the act says gratuity shall be payable, that's not a suggestion. It makes it a mandatory part of your compensation.
Yeah.
Legally enforceable.
Right. So it's earned, which means it does two big things. First, the obvious one, it's a safety net. Provides a financial cushion when something major happens, like retirement, quitting, superannuation, or sadly, death or disablement.
Absolutely. And the second thing, which is kind of the clever bit strategically, often gets missed. The act actually uses this benefit as a way to keep people around. That main condition, you need 5 years of continuous service, that creates this pretty big financial reason to stay put.
Oh.
If you're thinking about leaving, say, 4.5 years in, that 5-year line is like a financial cliff, right? Leave a day early, you get zero statutorily, wait just a bit longer, and boom, you get this potentially significant tax-friendly payout.
So for the employer, it's actually a cheap way to encourage loyalty, especially in those first crucial 5 years, helps keep attrition down for newer folks nearing that point.
Precisely. It's like a built-in incentive for stability. And this law, it reaches everywhere. Applies to the whole of India, J&K, Ladakh included since the 2019 update. Uniform rules nationwide. Covers the obvious places like factories, mines, ports, railways. But also any shop or establishment that has 10 or more employees working on any single day in the last 12 months.
Okay, and that 10 employee number, that brings us right to this major headache, especially for smaller businesses, SMEs. You called it the sticky liability. Can you break that down? Sounds ominous.
It is a bit ominous for planning. It comes from Section 1, subsection 3A of the Act, the once applicable, always applicable doctrine. Basically, the second your business hits that 10-employee mark, even just for one day, the Gratuity Act applies to you forever. It's like flipping a switch you can't flip back.
Wait, forever? Seriously? So if a small company hires up to, say, 12 people for a busy season, then scales back down to 7 the next year, they're still on the hook.
That's exactly it. You can't just shake off the obligation because your headcount drops below 10 later. It sticks. That's why we call it sticky liability. It takes what might seem like a temporary cost and turns it into this permanent growing financial liability that has to be properly accounted for on your balance sheet, under the accounting standards. It's a one-way street into permanent responsibility under this act.
Wow. So hiring employee number 10 isn't just about payroll. It's a massive strategic financial decision, a point of no return for an SME.
Fundamentally changes their risk profile and the admin burden too.
Okay, let's shift to the nuts and bolts section 2, core definitions. Everything, the calculations, the liability, it all hinges on what these words legally mean. Let's start with who this law protects, the employee.
Right. The definition of employee in the Act is deliberately wide.
Yeah.
It covers basically anyone employed for wages, skilled, unskilled, manual, supervisory, technical, clerical. Doesn't matter. And importantly, unlike some other labor laws from back then, the Gratuity Act has no salary cap. So even high-earning managers are covered, as long as their job isn't purely administrative or executive decision-making.
And you mentioned there was a significant update, a correction almost, about who counts under this broad definition.
Yes, a really crucial one, the retrospective amendment in 2009. Before that, a Supreme Court ruling had actually excluded teachers from the Act's protection, which was frankly pretty unfair. The 2009 amendment specifically fixed that. It clarified that anyone doing any work connected to the establishment, explicitly including teachers, is covered. That was huge for the education sector. Teachers finally got access to this earned right.
That must have been a massive relief, correcting something that just didn't make sense anymore. Okay, now the definition that dictates the actual money, wages. Today, everyone talks CTC, cost to company, which includes everything, but the Act's definition here is, well, tiny in comparison.
It's shockingly narrow, almost feels archaic now. For gratuity calculation, wages means only two things: basic salary and dearness allowance, DA. That's it. Our sources really hammer this home. You have to understand what's excluded: bonuses, commission, house rent allowance, HRA, travel allowances, overtime pay, all specifically left out of the calculation base.
So companies often structure pay to keep the basic low and pump up allowances, maybe for tax reasons.
Right.
But doing that directly shrinks their future gratuity payout liability, creates a massive gap between what someone thinks they earn, their CTC, and what their gratuity is actually based on.
Exactly. It really shows this structural mismatch between the 1972 definition and how companies pay people today. It's a big reason why gratuity can seem like peanuts for higher earners and corporates, while for someone on a lower wage, it's a much more significant safety net.
Okay, next key term, family. This becomes incredibly important if, tragically, an employee passes away. Getting the nomination wrong here can cause huge legal problems.
Yeah, this one's strict. The legal definition of family is very precise. It includes the employee's spouse, their children, whether married or not, dependent parents, the dependent parents of their spouse, and also the widow and children of a son who died before the employee. If you try to nominate someone outside this list, like a brother or sister who isn't dependent, that nomination is legally invalid. Void. The rigidity is there to try and prevent messy family fights over the money later on.
Right. Makes sense. Now, the big hurdle for the employee, eligibility, this whole continuous service thing. The main rule for quitting, retiring, or superannuation is not less than 5 years of continuous service with the same employer.
And continuous service itself is defined in a very employee-friendly way. It's like a shield. The law is clear that your service isn't broken by normal things that happen in work life. Things like being off sick, having an accident, taking approved leave with full pay, being laid off, a strike or lockout, or any work stoppage that wasn't your fault. It protects your tenure during rough patches, personally or economically.
And didn't the Act get an update recently in 2018 to keep pace with things like maternity leave?
It did, yes. That 2018 amendment was vital for women employees. It bumped up the period counted as continuous service during maternity leave from 12 weeks to 26 weeks. This brought the Gratuity Act in line with the Maternity Benefit Act changes, making sure women don't lose out on their gratuity eligibility just for taking their legally entitled maternity leave.
Okay, this brings us to something that trips up a lot of people: calculation mistakes, compliance issues. There are these two different court-driven rules about service length. We need to be crystal clear on the difference between the 4 years and 240 days rule for eligibility and the rounding off rule for calculation.
Oh yeah, this is a classic compliance trap. Mix these up and you got an instant problem. So the 4 years and 240 days rule, this is the yes-no test. Did you qualify? Do you get gratuity at all? It generally applies if you work 6 days a week. If you finish 4 full years plus 240 days in that 5th year, boom. You've legally met the requirement. The right is yours. You are eligible.
Okay, so that's the gateway. Pass-fail.
Exactly. Now, the rounding off rule is totally separate. It only comes into play after you've passed the eligibility test and only to figure out the number of years used in the final money calculation. For the calculation part, if your service in that last year is more than 6 months, they round it up to the next full year. If it's 6 months or less, it stays as it is, essentially rounded down for that fraction.
Okay, let's walk through a couple of examples just to nail this down.
Good idea. Scenario 1. Employee works 4 years and 7 months. Have they hit 4 years and 240 days? No. 7 months is roughly 210 days.
Right.
Result: ineligible. The rounding rule doesn't even matter. No gratuity.
Scenario 2. Employee works 4 years and 10 months. That's definitely past 240 days.
Correct. So they are eligible. The right has vested. But crucially, they haven't completed 5 full years. So for the calculation, their service is still counted as 4 years. The rounding rule can't magically give them a 5th year they didn't actually complete.
Got it.
Okay, scenario 3. Employee works 5 years and 7 months. Clearly eligible past the 5-year mark. And now for the calculation, the extra 7 months is more than 6 months.
So it rounds up.
Exactly. Their service gets rounded up to 6 years for the final calculation. See, the eligibility hurdle is tough, but once you're over it, the calculation rule could be quite generous.
That distinction is super important. And of course, there's the exception that scraps the 5-year rule entirely, the humanitarian one.
Yes. If the reason for leaving employment is death or disablement, the 5-year minimum doesn't apply. If an employee becomes disabled from an accident or illness, or if they pass away, gratuity is payable immediately, no matter how short their service was. It ensures the money is there as a safety net right when it's most desperately needed.
Okay, so we know the base is just basic plus DA. Now let's see how that base gets used in the actual formula. Section 3, the financial mechanics.
Right. For most people, the monthly paid folks, the standard formula is gratuity equals last drawn wages times 1526 times the number of completed years of service, remembering the rounding rule.
Let's focus on that fraction. 1526. Okay, 15 makes sense, 15 days pay per year, but why divide by 26? Why not 30 or 31 for the days in a month?
The 26 denominator. That's not intuitive, is it? It's actually a deliberate choice baked into the law to benefit the employee. It comes from the Act's social welfare goal. The law basically assumes a 26-day working month. It takes out the 4 weekly off days. So when you divide the monthly wage, basic plus DA, by 26 instead of 30 or 31, you get a slightly higher notional daily wage.
Ah, clever.
It artificially inflates that daily figure, making the final 15-day calculation more generous than if they just used, say, half a month's salary, 1530. It's built-in generosity in the math itself.
That's a neat insight. Let's run the numbers quickly. Say last drawn basic plus DA is 80,000. Employee worked 15 years and 8 months.
Okay. Eligible, yes. Service rounds up to 16 years because 8 months is over 6 months.
Yeah.
Daily wage for calculation, 80,026. That's about 3,077. So the calculation is 3,077 by 15 days by 16 years. That comes out to roughly 738,462. If we'd used 1530, the payout would have been noticeably smaller.
Right. Now, the Act also covers people not paid monthly, like piece-rated workers or seasonal staff. How does that work?
Yeah, for piece-rated employees where pay can jump around a lot, last drawn wages doesn't really work. So the Act says you take the average of their total wages earned over the 3 calendar months right before they left. And it's crucial here the employer has to exclude any overtime pay from those 3 months. Keep the base clean, just regular earnings.
Makes sense. And seasonal workers. Like in agriculture or maybe sugar factories?
For seasonal employees who only work parts of the year, the yearly formula doesn't fit, so their gratuity is calculated differently. They get 7 days' wages for each season they worked. So someone works, say, 8 seasons, they get 8 times 7 days' wages based on their seasonal rate. It reflects their specific work pattern.
Okay. Finally, on the money side, let's talk limits. The statutory ceiling and how tax works under Section 10. What's the maximum amount payable by law right now, and is it actually keeping up?
The current legal cap is 20,020 lakh rupees. That was set back in 2018. If an employer wants to pay more than that, they can, but anything above 20 lakh is considered ex gratia, basically a voluntary top-up.
And that extra bit, the extra share payment, is fully taxable income for the employee, right? Takes some of the shine off. Is Uri lakh still a meaningful limit for senior folks?
For many mid-level employees, 20 lakh is still a very significant amount. But for senior management, especially those with high basic salaries, honestly, the statutory limit is starting to feel a bit low compared to their overall packages. It's a ceiling that probably needs regular adjustment.
Now, the tricky bit, tax treatment. Section 10 of the Income Tax Act. How does that work?
Okay, it depends. First, government employees, central and state, they get the best deal. Their gratuity is completely tax-free. For everyone else in the private sector covered by the Act, the amount exempt from tax is the lowest of 3 figures.
The actual amount of gratuity they receive.
The statutory ceiling, which is currently 20 lakh.
The amount calculated using the Act's formula, that 1526 calculation.
Whichever of those 3 is the smallest, that's the amount exempt from tax. And one really important point. This 20 lakh ceiling is a cumulative lifetime limit. Any gratuity you received and got tax exemption on from previous jobs counts towards this cap.
Ooh, that lifetime limit is a sneaky detail many people probably forget when they switch jobs. Okay, that leads us nicely into Section 4, employer compliance and enforcement, the hidden dangers. You mentioned this compliance paradox, hardly any regular paperwork, which sounds good, but actually creates risk.
Exactly. It breeds this false sense of security. The danger is that compliance is event-driven. There are no monthly or annual returns to file for gratuity specifically. But certain administrative tasks become mandatory the moment specific things happen, like hiring that 10th person or an employee leaving. This means problems like missing records or wrong filings from years ago often only come to light right when an employee exits and the money is due. That's when the stakes are highest.
So what are these specific mandatory tasks triggered by events?
There are key forms. When a company first hits the 10-employee threshold, they need to file Form A, Notice of Opening, within 30 days. Then there's Form B for any changes, like address or business nature, and Form C if the establishment closes down. But maybe the most critical one operationally is Form F. When an employee completes 1 year of service, the employer has to get them to fill out this nomination form.
Form F, the nomination. Why is that one so crucial? Sounds like standard HR paperwork.
It seems simple, but it's legally vital. Form F is where the employee officially names who gets the gratuity if they pass away. The employer's job isn't just to collect it. They have to keep it safe, secure custody. If the worst happens, a properly filed Form F avoids the money getting stuck in legal limbo or family disputes for ages. If that form is missing or filled out wrong, it can mean years of delay and potential penalties for the employer. Oh, and they also have to display an abstract of the Act and Rules Form U somewhere obvious for employees to see.
Okay. Now, perhaps the biggest financial obligation, Section 4A, mandatory funding. This is what actually backs up the promise to pay, right? Protects the employee if the company goes bust.
Precisely. The law says employers, unless they're government bodies, must secure the money to cover their future gratuity payouts. They generally have 2 ways to do this. Either get a compulsory insurance policy, usually from someone like LIC, that covers the calculated liability, or they can set up an approved gratuity fund structured as an irrevocable trust.
And getting this funding isn't just about buying insurance or setting up a trust fund. It requires some serious financial foresight, right? This is where accounting standards become key.
Absolutely. This funding rule forces proper accounting discipline. It means getting an annual actuarial valuation done by a qualified actuary. This is usually guided by Accounting Standard 15, AS15, or the newer IND-S 19. These standards are critical because gratuity is a defined benefit. The employer promises a specific future payout based on salary and service. The actuary has to project this future cost, considering things like expected salary hikes, employee ages, how many might leave, even mortality rates. It's complex. They need to ensure the money being put aside today is enough to cover those promises tomorrow. It makes the liability a concrete audited number on the balance sheet.
Right. It's not just a potential cost, it's a provisioned one. Now, what about actually paying out? The settlement procedure has strict timelines, and the onus is on the employer.
Yes, this is the employer's suo motu duty. They have to act on their own initiative under Section 7.2. They can't just sit back and wait for the employee to ask for the money. As soon as gratuity becomes payable, like the day someone retires, the employer has to figure out the amount and send the employee a notice saying how much they'll get and when. This stops employers just delaying things.
And what are the deadlines for this?
Very strict. The notice about the amount that's Form L if they're paying, or Form M if they're rejecting the claim, for some reason has to go out within 15 days of the gratuity becoming payable. Then the actual payment has to be made within 30 days of that payable date.
15 days for notice, 30 days for payment. What if they miss that 30-day deadline? What are the consequences?
Penalties kick in straight away. If the payment is late, even by a day past the 30 days, the employer automatically owes simple interest. The rate is set by the government. Currently, it's 10% per year. This interest runs from the date the gratuity was due until the date it's actually paid. It's meant to compensate the employee for the delay.
And if the employer just digs their heels in and refuses to pay even after being told to, who enforces it?
That's when the controlling authority gets involved.
Yeah.
This is usually a state government official, like an assistant labor commissioner. If the employer still doesn't pay after the authority directs them to, things get serious. The authority can start recovery proceedings, treating the unpaid gratuity like overdue property taxes, a powerful legal tool called arrears of land revenue. And this recovery includes not just the principal and the simple interest, but compound interest as well. That's punitive, designed to penalize deliberate non-payment.
And it doesn't stop at financial penalties, does it? There can be criminal charges, too.
That's right. Deliberately not paying or trying to cheat the system by making false statements is a criminal offense under the Act. This can lead to significant fines up to 20,000 euros, perhaps. But more critically, it can mean imprisonment for up to 1 year for the employer or the managers responsible. That threat usually makes timely payment a very high priority.
Okay, before we look forward, let's cover the rare exception. Forfeiture. When can this earned right actually be taken away? The Act is pretty tight on this.
Extremely tight, because you're taking away something someone has earned. Section 4.6 lays out very specific narrow grounds. First, partial forfeiture. If an employee caused financial damage or loss to the company through their own deliberate negligence or wrongdoing, the employer can withhold gratuity, but only up to the amount of the actual loss caused.
So if the employee caused 1 lakh loss, but their gratuity was 5 lakh, the employer can only keep the 1 lakh.
Exactly. It has to be proportional. The second ground is more serious and allows for whole or partial forfeiture. This applies if the employee was fired for riotous or disorderly conduct, violence, or committing an offense involving moral turpitude while employed.
And moral turpitude, that term caused some confusion legally, didn't it? But a recent court case clarified things.
Yes, a major Supreme Court ruling, the Western Coalfields case from early 2025, was really important here. It cleared up a big question about moral turpitude. The key takeaway was, an employer does not need a criminal conviction from a court to start the forfeiture process on these grounds.
Okay, so if not a court conviction, what is enough justification for the employer?
A finding of guilt from a fair, properly conducted internal investigation, a departmental inquiry, is sufficient. But, and this is crucial, the employer has to follow all the rules of natural justice, give the employee a chance to defend themselves, ensure procedural fairness. And the court also strongly emphasized proportionality. The punishment, forfeiture, must fit the crime, the misconduct. For example, the court suggested that for a minor case of theft or misappropriation, taking away the entire gratuity might be too harsh. Maybe only a partial forfeiture, like 25% or 50%, would be appropriate.
Right, so it sets a standard for employers, but demands real integrity in how they handle those internal processes. Okay, finally, let's gaze into the crystal ball. Section V, the future landscape. You mentioned we're in a bit of legislative limbo right now.
We really are. The old 1972 Act is still the law of the land today. But everyone knows the Code on Social Security 2020 is waiting in the wings to replace it, along with several other laws. So businesses are in this slightly awkward spot. They need to be perfectly compliant with the 1972 Act right now, but they also need to be actively planning and modeling for the huge changes the new code will bring whenever it's fully implemented.
And the code brings two massive changes related to gratuity. First, how it treats fixed-term employees.
Yes, this is a big one. Under the current Act, fixed-term employees generally need to hit that 5-year mark too, which is often impossible given contract lengths. The new code says gratuity will be paid pro rata to fixed-term employees when their contract ends naturally. The 5-year requirement is essentially waived for them in that scenario. This closes a loophole and instantly creates a new, ongoing, calculable liability for any company that relies heavily on fixed-term contracts.
Okay, that's significant. And the second change, possibly even bigger financially, is the new definition of wages in the code. This tackles that narrow basic plus DA issue head-on.
This is the one causing the most financial anxiety, I think. The code brings in a new, single definition of wages that applies across various Social Security laws. The killer rule is this: components normally excluded from wages like HRA, allowances, commissions cannot add up to more than 50% of the employee's total pay, total remuneration.
Okay, and if those excluded bits do currently make up more than half the pay package?
Then the excess amount, the amount above that 50% threshold, gets automatically pulled into the definition of wages for calculating benefits like gratuity. It's a direct hit against companies that deliberately kept basic DA low to minimize Social Security costs.
Let's put some numbers on that, because this is where people are talking about a potential 30-40% jump in liability overnight.
Okay, simple example. Employees' total monthly pay, remuneration, is $100,000 play. Right. Under the current 1972 Act, maybe their basic is $30,000 and DA is $20,000. Gratuity base is your $50,000. The other $50,000 is allowances, HRA, etc.
Right, so excluded components are $50,000, which is exactly 50% of the total $100,000.
Correct. So under the new code's 50% rule, this structure is fine. The gratuity base stays $50,000 total, no change. But now imagine a different company paying the same $100,000 total, but they structured it as basic DA only at $30,000 total and $70,000 in allowances to keep the gratuity base super low.
Ah, so now their excluded allowances, $70,000, are more than the 50% threshold, which is $50,000 on $100,000 total.
Exactly. The excess is $20,000 on $70,000 allowances minus the $50,000 threshold. This excess €20,000 must now be added to the statutory wages. So the new gratuity base isn't the old $30,000 anymore. It becomes $30,000 original basic DA plus $20,000 the excess. The new base jumps to $50,000. That's a sudden, massive percentage increase in the base used for calculation, maybe around 67% in this specific case. It means an immediate, unavoidable spike in the company's actuarial liability that they have to fund.
Wow, yeah, that is a huge jump. Companies need to be modeling that potential impact right now, no matter when the code actually kicks in. Okay, last piece of the future puzzle, the statutory ceiling. Looks like it's heading up from 20 lakh to 25 lakh. Based on this parity principle.
It looks very likely. The pattern is pretty clear. The central government already increased the gratuity limit for its own employees to 25 lakh back in May 2024, applying it retrospectively from January 1st, 2024. This happened automatically based on a formula leaked to dearness allowance hitting 50% of basic pay.
And historically, when the government raises its limit, the private sector follows.
History suggests exactly that. The previous increases for the private sector, up to 10 lakh in 2010, then up to 20 lakh in 2018, both came after similar increases for government employees following pay commission recommendations. There was political pressure, union demands. Trade unions are already asking for the same 25 lakh parity now. So any smart employer should see this historical pattern as a very strong indicator. They really need to start modeling and potentially provisioning for a 25 lakh ceiling now, because the amendment seems almost inevitable, probably sooner rather than later.
Okay, this has been incredibly thorough, a necessary deep dive. We've really established that gratuity isn't simple. It's this complex mix of Social Security law, financial planning, and strict compliance.
Yeah, I think the big takeaway is that getting the process right is just as important as getting the calculation right. Things like the mandatory funding under AS-15, keeping that Form F nomination safe after year one, hitting those 30-day payment deadlines. These aren't optional extras. Messing up the process leads straight to financial penalties, interest payments, and potentially even criminal liability for management. You just can't afford to be sloppy.
And that final thought we touched on, the sticky liability combined with that mandatory funding. It just changes the game entirely for businesses as they grow.
It really does. That moment, a small business hires its 10th employee. It's not just adding one more salary to the payroll. They're literally creating a permanent, ongoing financial obligation on their books. An obligation that needs complex actuarial math and actual funded security. Forever.
It's the day that small business effectively signs up for permanent accountability under one of the country's most significant and maybe most underestimated labor laws. How many SMEs really factor in the true long-term cost of that permanent growing liability the day they hire person number 10? That's the question, the financial reality check everyone should probably be asking themselves right now.